I'm very, very bad at it. In this presentation, I'm going to address a couple of subjects that I've called hot topics because either they're new or they're controversial or they're both. There are three, really. The first is the privacy issue and tension that I perceive, at least, between the desire to provide better protection for what is undebatably very private, very personal information on the one hand, and a desire for greater access to care for those in our country, and unfortunately they are extremely numerous, suffering from substance use disorder. The second is management of substance use disorder via telemedicine, via distance care, and the third is a few words about augmented, as we say, intelligence. A few disclaimers, I'm not going to read these. I will issue this. Any one of those topics could easily be a webinar or seminar unto itself. So this will be hit and run, very brief commentary on each of these subjects, and I just hit it the wrong way. I can't seem to get it to advance. All right, good. The GDPR, as I assume most of you know, is this European regulation that has become the 800-pound gorilla of European privacy law. It's complicated. It's extremely extensive in its reaches. Here in the state of California, which in lots of arenas of the law is something of a path breaker in the United States, there is a statute that has been enacted, or that will become effective January 1, that in many respects patterns itself after the GDPR. That is, it has a very, very expansive notion of what is considered private information. It greatly expands the ability of the public to learn what information an organization has accumulated about that person, and it gives, to an extent not previously seen, considerable opportunity to the subject of that information to ask that it be changed or deleted. The right to be forgotten, pioneered by the Europeans, is in some sense about to become the law here in California. Now, interestingly, there's an exception for protected health information as that term is understood under HIPAA. But that exemption does not apply to medical information that is not maintained by a covered entity, such as the three that HIPAA recognizes. It would not extend, for example, to medical information contained in employment records, as, for example, people who have short-term disability, for example. There is no protection for that, and it comes under the new privacy law here in California. So, come January 1, those of you who operate here, and I assume that's a healthy fraction of this audience, need to be aware of this if you're not already. Interestingly, though, although California is thought of as a front runner, Nevada, next door, has actually beat them to the punch. Effective yesterday, Nevada has enacted a statute that likewise expands privacy protections for not only medical information, but other kinds of consumer information. So we see this emphasis now on higher, better quality protection for very sensitive subjects. The other side, however, is that we are changing the laws relevant to information concerning SUD patients in a way to expand access to care, or so it is hoped, and to improve coordination of care. 42 CFR Part 2 is a lengthy portion of the Code of Federal Regulations that was pre-HIPAA. It existed before HIPAA was enacted, and it provides extraordinarily extensive protection for the highly sensitive information of patients who suffer from this particular problem. And it was intended, of course, to try to encourage them to seek medical attention and to prevent them from being exposed, for example, to criminal liability as a result of being candid with their healthcare professionals. Well, we are now tinkering a bit with 42 CFR Part 2 in a manner to make it easier for health professionals to be aware of a particular patient's SUD problem, and therefore to take it into account in designing care intended for the benefit of that person. So, for example, under the modification of Part 2, which again is under HHS's control and does not require congressional action, as TJ was pointing out is the case with some aspects of Medicare. If, for example, an SUD patient discloses to an employee of say a hospital that has a controlled substances unit, or offers special care for that type of problem, and in an incidental communication by text or by email, the patient discloses confidential information to an employee of that entity. Now, under the modification of the law, it's possible for that employee to comply with the law and to respect the patient's privacy adequately from a legal perspective merely by deleting it. Before we made that change, a lot more hoops had to be jumped through before you would comply with the law and comply with 42 CFR. Jesse's Law is a statute that was enacted by Congress in response to a tragic situation A young woman was addicted to pain-killing medications and was recovering and doing fairly well. In fact, was competing in athletic competitions. She injured herself in a race, a foot race, requiring surgery. And unfortunately, the record, which was created in an effort to be very protective of this highly sensitive bit of information, namely her substance use disorder, a fact that had been disclosed to the care team, not only by the patient herself, but also by her parents, and was present in the chart 8 different places. The discharging physician, the one who wrote the medications that were to be taken after she was released, was somehow not aware of this problem and wrote for oxycodone. Unfortunately, she overdosed on that medication and died. So we have now changed the law so as to make it possible, without legal liability, to make plain in a chart, to a far more extensive extent than was the case before, matters such as substance use disorder. So on the one hand, we're protecting privacy. On the other, in order to deal with substance use problems, we are, in a sense, liberalizing the rules or making them a little bit less patient protective. Have we struck the right balance? I think it's a matter of debate, but that's what's going on. Now, I mentioned the second topic, which is management of SUD via telemedicine. Everybody in this room probably knows about the Ryan-Haidt Act, enacted in 2008. It made 7 exceptions to the basic rule that no physician, no prescriber, was to write for controlled substances for any patient whom he had not physically examined at least once. Well, the 7 exceptions, for the most part, are all related to telemedicine in one form or fashion, but they're not very practically useful. For example, if you confine your practice to the care of people living on Indian reservations, or your VA doc, then you have exceptions under the Ryan-Haidt Act that enable you to write for these drugs, even though you haven't seen a patient in person. The 7th of the 7 listed exceptions, the special registrations so-called, was supposed to be the law, and indeed it is, but it is a meaningless phrase at present. Because when Congress enacted Ryan-Haidt, it did not, in fact, impose any obligation. It merely asked that the AG's office and the DEA get together and put flesh on the meat of the bones here, put something together to help us understand what special registration means. Unfortunately, DEA and AG didn't do that. Last year, Congress enacted a new statute saying, you guys need to get your act together and come out with regulations to tell us what this means. That information is supposed to be public on October 24th, 22 days from today. To the best of my knowledge, there have been no public disclosures of what the government has in mind, and so 22 days from now, supposedly, we're going to find out whatever special registration means. I suspect that we were going to miss out on that deadline. Now, I want to talk, sorry, I did it again, sorry. Artificial intelligence. There are multiple examples. I'm not going to belabor all of these. One that I'm especially fond of, I have to say, that I just read about recently, is the application of AI in echocardiography. In echocardiography, sound waves are bounced against the heart, and a skilled interpreter can tell you a lot about the structure of the heart, about heart valvular disease in particular, about pericardial effusions, and a variety of other things. Well, now AI has been applied to this technology so that the person using the transducer, which requires some skill to use properly, is actually coached through the process. The machine will tell you where to put the transducer, at what angle to hold it against the chest, so as to provide images of diagnostic usefulness. That, to me, is truly exciting. That's part of why telemedicine has intrigued me for 25 years. This is a way of providing care that would not be possible otherwise. We can take a layperson in the middle of nowhere, if he's got the equipment, which is admittedly a big if, but we can take a layperson and have him use this device to provide diagnostically useful information that can be shipped 1,000 miles away to a cardiologist to interpret what's wrong with the heart. I think that's really sensational. But the legal issues that attend this type of care are just extraordinary and mind-boggling. By no means am I an intellectual property lawyer. I don't play one on TV. I can say there are all sorts of interesting questions that arise for this kind of technology. If AI comes out with an algorithm or some other, effectively, device, who's the inventor of that device, if any? And how are we going to protect that intellectual property? Are we going to use patent law? Are we going to use contract? Are we going to use both? Nobody really knows. What about tort? There are all sorts of interesting questions. Suppose that AI gives you the wrong answer, which is at least theoretically possible. In fact, I love this example. If you want to confuse an AI system trained in dermatology, show it images of skin lesions beneath which one finds a ruler. And what the AI will do, it will err more often on the side of concluding that that must be a malignant lesion because of the presence of the ruler. Why? Because in the data that it has been fed to train it, whenever there's a pathological lesion, the pathologist has put a ruler beneath the skin lesion, and that's therefore an association between the two. It has nothing to do with the actual pathology. There are many, many other examples. We don't know who's going to regulate this. We don't know how to write the contracts for it. There is a real issue with bias, a real concern that the data that are used to train the AI may have too much of a skew towards white males, or at least whites, in our society, and not enough information about minorities of various kinds, which could result in bad, well, garbage in, garbage out, to borrow from this morning. All of these issues and many more are around with AI. There's a real concern among some physicians that AI might put them out of business. There's some concern among lawyers as well, which may be of good news to this audience, I don't know, because, for example, certain contracts are fairly repetitive, and one could theoretically program AI to write a contract. But because of this list of issues and a dozen others that I could cite, I suspect that there will be opportunities for professional engagements with lawyers in the future. Thank you.